Hello everyone, welcome to today's event on mediation in criminal cases. This is something that we usually get quite a lot of questions about in the chat, so it's really exciting to have some experts here with us today. First, I'm just going to go over some information about MediateGuru. So as a lot of you may know, MediateGuru is a social initiative led by members across the globe. And the aim of our organization is to bridge the gap between the public and litigation by creating a social awareness campaign showcasing mediation as the future. So far, we've conducted international webinars and have a reach in over 60 countries across the globe. And we aim to bring you access to the best lecture series so that you can add value to your legal studies and your legal career. So I'm now going to introduce our esteemed guests for today's session. We have three renowned experts with us today. First, we have Dr. Ashu Dhiman, and she is an assistant professor of law at the Center of Legal Studies in Gitarattan International Business School. She's also editor-in-chief at LicitElite and a member of the Women's Indian Chamber of Commerce and Industry. She's also authored many articles and research papers and has been published in various national and international journals. She's also organized national moot courts, conferences, and debate competitions. We also have with us Pascal Comvalius. He is a certified mediator and crisis negotiator, and he holds a master's degree in communication, behavior, and credibility analysis. He practices in the USA, Europe, Middle East, and Asia, and specializes in family and criminal law. He's also the current chair of the International Mediation Institute Appraisal Committee. Finally, last but not least, we have with us Ms. Vassiliki Koumpli. She is a Supreme Court lawyer and mediator based in Athens, Greece. She is also a mediation trainer at Panteion University of Social Sciences, and she is a senior legal expert at the Hellenic Institutes of International and Foreign Law. She regularly lectures in Greece and abroad and is constantly engaging in organizations for the promotion of mediation worldwide. So we're very lucky to have these three experts with us today. And I'd now like to invite each of the speakers to shed some light on today's topic, beginning with Dr. Ashu.
Thank you so much, Ms. Murray, for introducing me with the participant. I wish you a very good evening, and I feel honored to be here along with such eminent co-panelists to discuss criminal law and mediation. So friends, this concept has fascinated the legal industry for some time now, and I believe today's session will extend some clarity on the various aspects of existing as well as possible involvement of mediation in criminal law. And I will try to cover the scope in Indian context itself. So I understand that using slides in panel discussion is somehow weird, but I want you all understand what exactly I want to tell you so that you can just have a overview of the things I'm going to discuss. So that's why I'm sharing this PowerPoint slides with you. Okay, somebody can change these for me. Okay, yeah. So first of all, I just believe that all the students, all the participants are aware of kinds of alternative dispute resolution because we are going to discuss mediation, and definitely mediation is one of them. So unlike the writs and petitions filed in the court, alternative justice is a kind of the proper judicial trials. So mediation is somehow a client-driven process. Here, the parties are appointed and a neutral party to mediate in a dispute that has arisen between the parties. So a case can be referred to mediation in the pre-litigation stage, or even during litigation if the judge thinks it fit to do so, and the case to be referred to a mediator. So mediation is completely a private endeavor where the parties and their facts are kept confidential. So ADR components are profoundly established in Indian culture. As I have already said that I am going to take up Indian perspective if I talk about criminal mediation or in Indian context itself. So if we see Lord Krishna's period, we can find that from Lord Krishna mediating between Kauravas and Pandavas in Mahabharata to family elders who keep on resolving domestic disputes, domestic issues, to the resolution of dispute at community level. As we all know that we have Gram Panchayat on community level, there exists a strong culture of mediation in India. So, in ongoing occasions, the intervention has developed as the most favored method of debate cool, in which a non-partisan outsider helps the gatherings at a question to show up an agreement with solid evidence and convincing arguments. So,
We appear to be having some technical difficulties. Dr. Ashu, can you hear us? Well, it appears that Dr. Ashu is having some technical difficulties on her side. I think she has maybe a connection problem. Please bear with us. Okay, perhaps for now, unless Dr. Ashu returns very shortly, we should invite Pascal to take the stage and shed some light on his work. Pascal, would you like to take over? Thank you.
Of course. I'm happy to do so, and please feel free to interrupt me as the person is coming along. To give some light. So first of all, which might be sound as a surprise, no, I do not have a law degree. And yet I get this question asked all the time. So how is it possible that you're even mediating criminal cases? So I would argue first, okay, so what is normally then the issue? Is the law the issue here, or are just people having the issue? And I believe that people are having the issue. Yes, we need to take the law into account and address that just accordingly. But first, we focus us on the people, how they get their case solved. So that's what a little just background, just how I look at it at this part of the criminal mediation. And of course, I'll be going into this wonderful workshop, go into more and more just detail. And I will even share you some stories which might sound really crazy to you, where I was still able to reach an agreement. I believe Doctor has joined us again, so does she want to take over
again? Dr. Ashu, we lost you for a minute there. Would you like to finish your talk? Would you?
Yeah, okay. Yeah, I was just about to tell everyone about the criminal mediation in India. And I was telling them that there is actually, whenever we talk about criminal mediation in India, we are actually shifting. It can be said to be a shifting towards restorative justice if we talk about it, because ADR in criminal context actually represents a shift towards restorative justice, which views the crime as violation of one person's right by another person, and justice in criminal context should focus on repairing the victim's harm. So, if we talk about ADR in criminal aspect, it contains the idea of reparation in the transitional justice aspect, which might not be a component of civil mediation, because civil mediation is somehow different from criminal mediation. So, reparation, if we talk about reparation, it actually refers to an act on the part of the offender to do something positive towards on the behalf of victim and the society, which may involve compensation. And Indian courts has never been familiar or happy with the concept of taking mediation in criminal cases, because they think that it is the final settlement is actually the party centric and it is not the society centric. So Indian criminal justice system was not actually open to the idea to include the option of mediation, and it was definitely evident from Athens infrastructure and others versus sharing and others, in which it was held that criminal cases shall not be decided by alternate dispute resolution methods. And even, am I audible?
Yes, we can hear you.
Okay, so I was telling you about the Indian judicial system, which hasn't accepted as such. Even in 2010, the Supreme Court was against it. Then comes the concept of inclusion of plea bargaining, and even again, the Supreme Court was not in favor of introducing the plea bargaining. And I hope everybody knows what is plea bargaining. It is actually successfully practiced in many jurisprudence around the globe, and it may be understood as pre-trial settlement between the accused and prosecution on the pretext wherein the accused pleads to be guilty in order to receive some concessions by the prosecution. And definitely, I have already told that Supreme Court was not in favor of inclusion of concept of plea bargaining, and it is evident from Muralidhar's case and Kasam Bhai's case as well. And there is Teppaswamy versus State of Karnataka's case. So it was first in 154th report of Law Commission of India when it firstly suggested in Indian criminal jurisprudence the concept of plea bargaining. And there was Criminal Procedure Code 1973, which was again amended, and it received Chapter 21A, which was including sections 265A to 265L, which was talking about plea bargaining, the concept of plea bargaining, and it allowed the plea bargaining for cases wherein the maximum imprisonment is for 7 years, wherein the offences does not affect the socio-economic condition of the country, and also where offences not committed against the women and children below 14 years. So definitely we can see that there is inclusion of plea bargaining. So somehow we can say that Indian judicial system has introduced mediation in criminal law. But still, if we talk about heinous crimes, so Indian judicial system is actually not ready to take up the mediation rather than litigation, because they believe that it is against the public policy and it is against the right to life and personal liberty. So that is why Indian judicial system is somehow against this concept, because they feel that it is party-centric. So domestic courts perspective is, however, changing day by day, and they say that yes, in civil proceedings they can go for mediation, but in criminal one there are still some loopholes which can be left behind if we talk about these criminal mediation things. But there are many cases to talk about. There are Prabhat Bhai Ahir's case, and there are many other cases in which civil as well as criminal mediation has been taken up. So while considering the reference to parties to a criminal case to mediation must before even ascertaining as to whether elements of settlement exist, first example, or examined by preliminary scrutiny. So basically, the mediator has to do one thing before commencing the mediation, must undertake preliminary scrutiny of the facts of the criminal case and satisfy himself as possibility of assisting the parties to such settlement as would be acceptable to the court. So the inclusion of section 482 of CRPC, where the High Court has the power to exercise compounding of offences, that is also one of the examples that Indian usually is mediation law. And there are other international perspectives. If we talk about United States of America, the victim offender mediation process has been established. In Philippines as well, there is Bagani justice system, which consists of locally elected Bagani captain and a peacekeeping committee. Czech Republic also has the probation and mediation service, and it is involved in partial and court proceedings in an attempt to mediate effective and pro-social resolution to crime-related conflicts. Even in New Zealand, there is a community and family group concerning model. And if we talk about South Africa, there is also community conferencing that is used sometimes as an alternative measure program to which an offender can be diverted from criminal justice system. So we can see that in around the globe, the mediation in criminal law has been accepted. So Indian criminal jurisprudence has moved on from not recognizing the concept of alternative dispute resolution in criminal matters to adding the concept of pre-bargaining into CRPC and also forming guidelines to recognize the mutually agreed settlement by parties to the dispute in case which are not of a serious nature and does not impact the society at large. ADR is an exception to the traditional court procedures and should be used more comprehensively and regularly. Therefore, such outside court settlements are important to reduce the exorbitant burden on the court and should also become the new normal. Thank you so much.
Thank you, Dr. Ashu. Thank you for bearing with us with the technical difficulties. That was a very insightful presentation. I'd like to invite Pascal back now to finish his introduction. Thank you for bearing with us, Pascal.
Yeah, no worries. So, looking just back at what's just been told. So in the Netherlands, where I practice criminal mediation, it's a process next to the whole court proceedings itself. So what we see, whatever is being discussed and being agreed upon will be taken into account towards the end. The judge will look at it and can say, "Hey, these are really good results. They don't need me anymore, so the case will be dismissed." Or still, there could be possibilities where we say, "Oh well, yeah, it's great that you make all these the beautiful agreement, but still, I believe there has to be some sort of punishment," which could be for a severe case where the public audience might say, "Well, hey, it's still so important to us that people need to be punished for that." But overall, we see in the Netherlands that in the jurisdiction of The Hague, where I'm situated, we have a 90% rate of just coming to an agreement, which is exceptionally high, which suggests us over just the past 8 years when we started this, that we are capable of putting it off and with a high satisfaction rate. Also from the victim side, but from the offender side as well. So that was just a short introduction given I would like to give Ms. Koumpli just more room for that.
Okay, thank you, Pascal. That's interesting. That's such a high agreement rate. Okay, finally, we're going to hear from Ms. Vassiliki, who's waited quite a while now. So I will pass over to you, Vassiliki. Thank you.
Thank you very much, Phoebe. I would like to thank all the organizers of the MediateGuru for the kind invitation, as well as our esteemed audience joining the today's session, first of all. One may notice, from my point of view, that the topic of this workshop, criminal mediation, has been, in fact, under-discussed or under-analyzed in international scholarships and doctrine as compared to other fields of application of mediation, such as mediation in civil and commercial matters. Nevertheless, we all know that it is gaining more and more importance in many, many countries. In Greece, the jurisdiction that I am familiar with, criminal mediation per se is only expressly provided in cases of domestic violence, misdemeanors, not felonies, and is conducted by the prosecutor. The outcome may be an agreement which includes the offender's apology and promise to never repeat the crime, as well as his removal from the home of the victim and maybe other remedies too. Another process, a criminal conciliation, not mediation, we've used another word in this piece of legislation, is also provided for particular crimes, financial crimes such as theft, embezzlement, forgery, fraud, computer fraud, infidelity, illegal trade, money laundering, or corruption. It is also conducted by the prosecutor and requires formal admission of guilt and the return of the proceedings of the crime. The offender may be sentenced to imprisonment of 1 or 2 years or community service, and the criminal procedure is suspended thereon. Such processes should be distinguished from the so-called plea bargaining, we heard already, which is allowed in Greek legislation in principle in all types of crime except terrorism, rape, and similar offenses. The agreement between the accused and the prosecutor, which also contains formal admission of guilt and the sentence proposal, taking into account the gravity of the offense and its overall circumstances, as well as the fault, the personality, and the financial status of the accused. In this process, we conclude, the process ends with the court imposing a sentence within the proposed framework or suspending criminal proceedings altogether. However, I have to underline that all these processes have admittedly extremely limited application in Greece so far. So I will be very, very glad to hear my colleagues, Ashu and Pascal, explain their experience, because in the Netherlands and India, I know that such processes are much more preferred. At this point, and before concluding this introduction, I think that special mention should be also made of the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, better known as the Istanbul Convention, which expressly provides that disputes arising regarding its application or interpretation should be first sought to be resolved by means of negotiation, conciliation, arbitration, or by other methods of peaceful settlement accepted by mutual agreement between the parties. This is an important step towards a universal acceptance of such methods of agreed solutions between the parties, offenders and victims. Thank you very much.
Thank you, Vassiliki. It's interesting to hear how things differ between the different countries. So now we're going to move on to the question and answer section of this session. And the first questions are for you, Vassiliki. So I would first like to ask you, what is criminal mediation? Can you tell us a bit about what criminal mediation involves, please?
So now let's start from the theoretical points and from a conceptual point of view. What is criminal mediation? Criminal mediation can be generally defined as a conflict resolution process that deals with violations of criminal laws by addressing also the underlying conflict and resulting injuries to the victim. I can say it emphasizes the right to participate in attempting, it emphasizes the right of the parties, the victim and the offender, to participate in attempting to achieve justice rather than deferring the matter entirely to state criminal processes. Participation is voluntary and the process is conducted in an informal setting by a third neutral person who may be either the prosecutor or judge or an external mediator, depending the scheme and the jurisdiction that we are talking about. Two significant models have so far emerged in the context of criminal cases. The first one is the restorative justice model. We all know this concept. And the second one is the case management model. The two models have completely different focus, different philosophies, and a different bargaining scheme. The restorative justice model, on the one hand, is the relationship-driven, focusing on healing and attaining closure, while forgiveness is also a central and contentious concept. On the other hand, the case management model is more settlement-driven, focusing on fostering settlement, saving resources in the administration of justice, and also reducing case workload. Moreover, there are variants in criminal mediation models across jurisdictions dictated by the role played by the threat neutral in mediation. For example, in certain American jurisdictions, the mediator plays an extensive role in resolving the dispute, being essentially allowed to give an evaluation of the strengths and weaknesses of the case. In Singapore, for instance, on the other hand, the role of the mediator is limited to the extent that he is only allowed to facilitate the session and not evaluate the case. I think that it is remarkable that criminal mediation inherently takes the form of a multi-party, multi-interest process. Because in the criminal arena, the identity of the stakeholders becomes more complicated as the prosecutor brings the charges on behalf of the government. So the government and not the actual victim appears to be a principal stakeholder too. Yet we should not forget that victims' interest in the matter still provides good reason to consider him a stakeholder with something more than a secondary interest. Moreover, as a general remark, a basic process now, we can say that typically involves 4 stages. The case referral, the preparation for mediation, the conduct of mediation itself, and any follow-up necessary, for instance, as regards the enforcement of restitution agreement. Often a case may be referred to mediation after a conviction, as Ashu mentioned, or after a formal admission of guilt in court, but some cases are diverted prior to such a disposition in an attempt to avoid prosecution. The mediator, who may be, as we already mentioned, the judge, the prosecutor, or a third outside mediator, external mediator, then contacts the parties to make sure that they are appropriate for mediation. In particular, he or she may seek assurances that they are psychologically capable of making the mediation a constructive experience, that the victim will not be further harmed by the meeting with the offender, and that they all understand the participation is voluntary. The parties then meet to identify the injustice, rectify the harm, to make things right or restore equity, and to establish payment or monitoring schedules. The parties present their version of the events leading up to the crime and the circumstances surrounding the crime, and the victim has a chance to speak about the personal dimensions of its victimization and loss, while the offender has a chance to express remorse and to explain circumstances surrounding his behavior. Then the parties agree on the particular nature and extent of the harm caused by the crime in order to identify, to find the acts necessary to repair the injury to the victim. The terms of the agreed reparation, which can be, for example, restitution or in-kind services, etc., are drawn up in writing, along with payment and monitoring schedules, as we said. And eventually, the court may acquit the offender or impose a minimal sentence and suspend the criminal proceedings altogether. Thank you, Phoebe.
Okay, thank you, Vassiliki. And could you tell us, please, what kind of cases are usually eligible for mediation?
Yeah, so the question here is, as I understand it, should criminal mediation be applied to all type of criminal cases, regardless of their type or of whether they are serious or minor? It has been argued that criminal mediation should only be applied to minor cases because it creates effective efficiency in the criminal justice system. Minor or low-impact crimes include civil offences against persons, such as assaults and threats, unlawful entries, offences against property, such as destruction of property, minor thefts, etc. But apart from clearing the criminal docket for more serious crime, which is the reason why this approach is suggested, criminal mediation of minor or low impact crimes is also seen to be more effective in addressing the underlying issues of these crimes. As far as I have noticed, many jurisdictions in the United States adhere to criminal mediation of low impact crimes for the reasons just mentioned, for example, District of Columbia or Delaware. However, other jurisdictions, such as Singapore, who came to my attention, recognize the need to consider all appropriate cases, minor or otherwise, for criminal mediation. This is regarded in this case as prudent and wise approach, as it is obvious that all cases subject to state court jurisdictions are capable eventually of contributing to court workload. Hence, if the main aim is to supplement the adversarial system in a most efficient manner with effective utilization of state resources, it must be the case that criminal mediation should not just be limited to low impact crimes. On the other hand, as I already mentioned in my introduction, there are cases such as the case of Greece, where particular crimes are classified as suitable for criminal mediation and are submitted to such a possibility. Thank you, Phoebe.
Okay, thank you. And I think you may have touched upon this already, but would you say in general the impact of mediation on criminal cases is a positive one then, that enables our justice system to become more efficient?
Yes, first of all, but okay, there are studies, apart from this apparent impression that it helps this way. There are some studies so far that have concluded that criminal mediation schemes, when they apply, have high rates as regards also client satisfaction, victim participation, as well as restitution completion, and they result as well in reduced fear among victims and reduced criminal behavior by offenders. More specifically, participating in criminal mediation has a positive and significant impact on participants who constantly report several months after the intervention that the outcome is working, the issues have been resolved, and they are satisfied with the process. And indeed, criminal mediations may resolve issues with outcomes that work in the long term and keep cases from returning to court with subsequent criminal charges. Mediation also can result in the use of fewer court and law enforcement resources in the short, but also in the long term. Nonetheless, we should note that, we should underline that mediating criminal cases bespeaks caution for all involved. The judicial mediator or the prosecutor, the defendant, the defense attorney, the external mediator, etc. Saving money and judicial efficiency cannot be allowed to erode the defendant's constitutional protections, of course. Prosecutors must be assured that the process will provide benefits worth the loss of control they have to face. And moreover, considerations of confidentiality and privilege must be addressed, as I think already Ashu mentioned in the case of India. So we should think, is criminal mediation potentially a fluid alternative to the adversarial process, or does it simply short-circuit the process? And what actually we do want in a particular jurisdiction. And of course, a lot of caution is also necessary so that the goal of lightening the court workload is not sought at the expense of seeking the essential truth. In many cases, for instance, the accused may be tempted to plead guilty so as to reach an agreement, even though he may be innocent. There is a case in the US Supreme Court, the case in North Carolina versus Alford in the 70s, I think 1970, having exactly this object that the accused pleaded guilty so as to reach an agreement, but eventually he was innocent, and this complicated the case.
Okay. Thank you, Vassiliki. So it's important that those safeguards remain for defendants then. Would you say that there are any other disadvantages potentially to mediating criminal cases?
That the disadvantages I just mentioned, that can be, of course, addressed this way. I don't have something to add, but I could go forward to see if there are particular advantages or disadvantages concerning the mediation in court or out of court, if you want me to do so.
Yes, that would be very helpful. Thank you, Vassiliki.
Yes, because through the fact that the mediation in court is part of the criminal justice process, as we mentioned, court annexed systems and schemes where the prosecutor or the judge mediator conducts mediation within the framework of the criminal proceedings. We can see some advantages in this respect. First, the due process rights are expected to be respected because we are in this environment. Second, the prosecutor can refer the case to mediation at any moment during the criminal proceedings, which help the process to benefit from both sides, from the mediation and the judicial environment too. Third, the prosecutor takes into consideration the outcome of the mediation in the formal charge. So such procedural and functional benefits, in my opinion, may hardly be found in a restorative mediation. At the same time, however, the dominant use of judges to facilitate case management, criminal mediation raises several concerns. I will focus on two here. And the first is the need for judges, among others, to receive a training in mediation. And the second is the potential for judges, because of the somber authority of their positions, to exert undue coercion on defendants that could lead defendants to plead guilty and waive their constitutional rights. Case management mediation or court mediation, with its narrow focus on settlement and clearing court calendars, may miss an important opportunity for healing and for essentially resolving the underlying conflict. In this respect, case management mediators could learn something from the restorative justice community. Restorative mediation appears to offer a creative and proven workable alternative to the retributive approach to dealing with crime, while case management mediation, by serving the function of judicial settlement, it appears to merely substitute one form of retributive justice. So the question is whether more should be expected of the developing case management process, and whether it should be viewed as an important opportunity to refocus the criminal justice system away from retribution to restoration. And this is a matter of policy and what the policymakers actually want. Thank you, Phoebe.
Thank you, Vassiliki. You've provided some very insightful answers there. My next question is for Mr. Pascal, and it is, what role does the lawyer play in this type of criminal mediation? Thank you.
A very important role. But before I go to that, I would like to just make some comments just what's just been said. But we see in the Netherlands, we see a sort of hybrid model where restorative part and the case management are coming together. We're looking at both of these parts. It's not as black and white with the cases I've seen. And the other thing is the pros and cons of mediating. As you were saying, Phoebe, in and out of court, we have our cases literally in court. And why is it that we have in court? For two reasons. One is the reasons of safety. We have an alarm button, so just in case it get out of control, we're always mediating with two mediators, also for the same reason, 4I principle. And So just in case it gets out of control, law enforcement can come up and split the parties. And the second, the minute, and you maybe you notice yourself, as soon as you approach or you get into court, you're like, oh wow, okay, this is getting serious. I better just do my utmost best or get my story right. So you see the push in themselves in order to express what they really need in order to resolve it. It's even enhanced in that sense. So going back to your question, what role does a lawyer play? A very important role. I believe it's a key. What you see also at the level of trust, who they trust the most is at that point their lawyer. It's their sort of defending, and they're dummy to dress them in front of them. And what you see, if we come to an agreement, there are certain juridical aspects just to it, and both of the parties need to make sure that they agree what's being that they know what they're agreeing to, whatever is in the agreement. So a lawyer can be then helpful in that to review it and see if that's be beneficial for either just from a victim perspective or a offender perspective.
Thank you, Pascal. I'm sure that will be useful to many of our future lawyers in the audience. My next question is for Dr. Ashu, and it is, what do you think? Shall we prefer solving problems faster by mediation or the strict scrutiny of the judiciary? Dr. Ashu, can you hear me? Dr. Ashu, are you there, please?
Yeah, I'm here. Thank you so much for the question. I understood that you want me to tell that what I think about the what should we prefer, like mediation or strict scrutiny of judiciary. See, if we again I take the Indian context in hand, because if we see that there are a number of cases pending in Indian courts, if we see Supreme Court itself, we'll find that there are around 60,000 cases which are pending in Indian Supreme Court, and more than 45 lakhs in various high courts and district courts. If we talk about district courts, in some courts we'll find that they are in crores. So there are pendency of these many cases because of low judges, strength and appointment, filing of irrelevant cases, and unnecessary public interest litigations, and misuse of process of law, lack of infrastructure to get the speedy trial is somehow fading day by day. So, as you might have heard the legal maxim which talks about justice delayed is justice denied. So, it is well established in present system of Indian judiciary. So obviously, if we talk about mediation in criminal context or in the context of judiciary itself, then we find that mediation is definitely better as it is efficient and effective. But the only difference being that mediation proceedings are party-centric, as I had discussed earlier while I was introducing the concept with you, then it is actually a party-centric. What about the society itself? Whereas when litigation takes place, it is actually for public good. So mediation can do wonders as it resolves the conflicts by reaching into mutual agreement, whereas litigation decides a winner and a loser, which is maybe what we need in an offense against the state. The main distinction is whether the crime or offense committed is committed against the state or itself or a person, in other words, the gravity of the offense. So definitely I would like to say that I would prefer mediation, but in Indian context, there are many pros and cons too. Thank you.
Thank you, Dr. Ashu. So now I'd like to invite Pascal back, and I'd like to ask, in what types of crimes has criminal mediation succeeded in the Netherlands? Thank you.
Well, in the whole aspect, as Ms. Koumpli already stated, so what type of case are eligible for mediation? we've seen that all type of cases are eligible for that, even murder cases. And you might think, oh, but that's impossible because that's such a ruinous crime. Yes, it is possible. So in the case that I've done, which was just this husband and wife, they had some difficulties. At one point, the husband strangled the wife, cut her up in pieces, put her in a garbage bag, and soon after that, they discovered it. So then you might think, well, this is just so obvious, but still, the family of the victim has still some questions. And there are three important questions we see within murder cases. Maybe, Phoebe, you can even think of them yourself. One of them is, of course, why did you do it?
Yeah.
Yeah, why? The other thing is, does he or she suffer? And the third one is, what are his or her last words? These questions we see coming back. But the beautiful, especially in this case, was the family of the victim when they were sitting together. And yes, it was this one was not at the court; it was at the prison. But he said, "You know what? Yeah, it's horrible that you've done something to our family member, but we do not necessarily want you to see you suffer. You need to get better. You need to work on yourself. And why would I say you deserve the death penalty, even of a horrible case, when there's so much sad things just going around in the world? And then so I want you to live, just to go on with your life and fight for it." And the murderer said, "Oh, that's beautiful." He was in tears, but offered then all the financial support, and the family needed financial support, whatever he was possible to do so. So we wrote it up in an agreement, and it was priced for a trial, and the judge took the outcome into account. Yes, of course, he deserved some jail time, but it was way shorter in order to have him just help them just out of this horrible situation. So hopefully that's answering your question, Phoebe. In what type of crimes has criminal mediation succeeded?
Gosh, that's fascinating. I would never have expected that. Thank you for sharing that with us. And more generally, what would you say is the role of the victim in a case management criminal mediation?
Well, I would, Phoebe, I would even think, so what's the role of both of them, actually?
Yeah.
Yes, we naturally think of the victim, but it's also just the offender. It is that, as Ms. Koumpli already said, there's that healing, there's the restorative aspect. And what we see in these sort of cases, it's about just perception. We all have a different perception. The way you look at me right now is different as the audience would probably see me. There's the element which Dr. Dhiman just mentioned, is the forgiveness part. And there's also the apology. And the apology is so important to combined with the context, with the perception. Oh, this is the reason, not that he didn't get away with it. So, and then the apology come forward, and if that accepted, because people, what you see, it then will be closed off for him, and it could be either just because of a sentiment they agree to a certain amount of money, or say like we leave each other alone, we will respect, or we only will say hello when we see each other, but that's it. It's sort of that's closure.
Okay, thank you, Pascal. That's good to know. We have two final questions, and they're for Dr. Ashu again. So, Dr. Ashu, please could you tell us about the role of the police officer in dispute resolution?
Yeah, of course. Whenever we talk about a police officer, in fact, in being citizens, we think about police officer. We always have a perception in mind, or we always think in back of our mind that police officer in uniform is there to catch the criminals or patrolling in his jurisdiction for maintaining law and order. But now modern policing is actually a resolution of conflicts of numerous kinds. They have required the status of an important task in the Charter of Police. So police officers are regularly called upon to deal with the conflict situations. So these range from acting as a mediator in a domestic dispute to resorting order in a public brawl. So individual officers have considerable discretion in their behavior. They resolve these disputes. Now, officers' approach or policing styles, depending upon a number of factors such as personality or experience. So, it is likely that from the wide range of styles shown by the police officer in journal, some strategies will prove more successful than others. So, that is, some police officer will more effectively deal with certain types of conflicts than other officers. Like in India, if we talk about family matters, so police usually try to resolve the issues of family-related matters in their on, and they don't let it go towards litigation, etc. So definitely, police has a very good role to play. And if we talk about Indian context, there is trust between the communities and law enforcement agencies, and it is often suboptimal, especially in the urban areas. So given that law enforcement agencies rely on community relationship and resources to provide and ensure public safety, so it is important to communities and police officers to have opportunity of dialogue, especially surrounding sensitive issues like religion and caste profiling and property disputes, sections of society having hostile attitude towards each other, and police responses in violent situations. So the conflict resolution fields offer many tools to help build bridges or fulfill the gaps between the communities and law enforcement agencies, including community dialogue, program for long-term systematic issues, as well as mediation for a short-term interpersonal disputes. Thank you.
Thank you. And finally, what would you encourage our law students in the audience to work on? What skills in order to pursue a career in criminal mediation?
First of all, before answering this question, I would like to talk about the questions I can see in the chat box, because students they actually want to know that can criminal mediation be done in the cases like murders or in heinous crimes, and one of the question was related to plea bargaining, etc. So I want to tell you one thing, that in case of plea bargaining, because plea bargaining is something which is not provided in India for all the cases. There are particular number of cases they have been identified in CRPC where plea bargaining can be taken up. And secondly, if we talk about murder, then you must be aware, because I have seen that there are many Indian students or Indian participants who have asked the question related to mediation in murder. See, if we talk about our society, we will see that deterrence is very important. So if there will be no deterrent effect of a punishment, because punishment is definitely important. The Supreme Court, I have already told you that the Supreme Court was of the view, and again is of the view, that if we are taking up criminal mediation in such cases, such heinous crime cases, then definitely the judiciary will fail for sure. Because in Indian context, we need to implement such policies or such punishments to provide criminal justice so that society can take more benefit. So that is why I'm not saying that it is impossible, it is possible, but somehow Supreme Court is of the view that it is against public policy as well as Article 21 of Indian Constitution. And now coming back to the question, of course, there must be, first of all, you must hold a degree. And secondly, if we talk about the law students, you must hold a degree. And then you need to be, for being a mediator, one person needs to be alert while talking to the parties to the dispute, and he should be patient, and he should have tact and credibility as well. So that, and also you need to have patience, credibility, and self-control as well to understand the parties, to understand the conflict they have. And so actually need to know about all the facts of whatever they are telling you, and you need to be very preservative. You need to understand, and you need to understand the thing that you need to take these things confidential as well. So there are many things to note about it. You may contact me as well if you want to know more about criminal mediation. Thank you.
Thank you. That's very helpful. I'd be interested to hear the other speakers' views on this as well. Skills that you think our students should develop to help with the criminal mediation career. So, Pascal, do you have any thoughts, please?
Well, there's a smile on my face, and I can understand it from what Dr. Ashu is arguing, that you need such a background in as a law degree, and whereas I do not have a law degree. So you see, it's working different in your jurisdiction. What's your I would think is your soft skills, and it's sort of a buzzword, but it is about listening. And it's active listening. And what do you do when you're active listening? As you're doing right now, Phoebe, you're nodding your head, you're engaged into it, but you ask questions. You ask the open-ended questions. And as long as you get questions and ask questions, you will get answers. You'll get a conversation. And it's not as black and white, like, oh, I will win this case. It's so strong. No, I believe in court, there's not just 50% chance, you have 33%. You either win, you lose, or the judge rules something entirely different, and you're still not satisfied. So that's why I'm just good. You want to, my argument, come to that mediation table, or use mediation as a tool. But it's more and more, yes, with law is definitely just, it's very helpful. Yes, I would, because I know just the background, but it's even more helpful to have these communicative and social skills.
Okay, thank you, Pascal. And Vassiliki, do you have any more thoughts on this for us, please? Oh, we have you now.
Okay. So I could not agree more with my esteemed colleagues, Ashu and Pascal. Okay, on the one hand is the degrees. Okay, if you are a lawyer in this process, you must have a law degree. If you act as a mediator, maybe this is not necessary. There are also other degrees that serve and help the mediator, behavioral sciences, psychology, criminology too. On the other hand, as Pascal mentioned very well, it's soft skills, human skills, communication, listening, and so on. But what I would like to add, apart from all these skills and beyond them, is to care about people, to care about the case. And this will help you to understand, to ask the questions, and to effectively communicate eventually. Thank you very much.
Thank you. Okay, I think this is about all we have time for today. We've gotten through all our questions, which is good. I'd like to thank all our speakers for providing their different perspectives on this. It's very insightful, and I'm sure it will help our students in the audience. I've also got to remind our students to please fill out the feedback form, which I think has been sent now, in order to receive your e-certificates of participation. And I hope to see you all soon at future events. Once again, thank you to all our speakers, and I hope that you have a brilliant rest of your day. Thank you, everyone.